Hello, everyone, and welcome to the webinar produced by Business Performance USA. And we're always honored to have you as our guest, and we know you'll gain a great deal from today's presentation. And as you know by now, if you've been joining us, Business Performance USA produces these weekly webinars on Tuesday at noon Central to provide business insights on a variety of very important topics today to business professionals. And we are, by the way, a voluntary association, and we provide online business information exchange. And when you become a member, you can meet people from across the U.S. engaged in business conversations on topics such as we are presenting today. And you can become a member at no cost and engage at any time. So just go to businessperformanceusa.org. And one of the many benefits is that you will be able to hear on demand all of the webinars we have presented this last year at a time when it's most convenient to you, including today's webinar. And today we are hearing back from Matt Graham, who will be talking about recent litigation trends as they are discussing background screening. So we're looking forward to that. And just so you know, I am Cynthia Stewart. I'm a managing partner for Evermore Services, and I'm your partner in building tomorrow's businesses today. And today we want to make sure that you make this hour worth your time. So use the question feature on the control panel, and all you have to do is type in a question, and I will be monitoring those so that when we get a break between Matt's slides, we can always ask those questions. So with that, let me go ahead and introduce our speaker today. This is Matt Graham, and Matt is the Vice President of Operations for Track One, which is a background screening company. And he's an Esquire with over 15 years of experience in employment practices. And Matt really is a bundle of experience and skills with his lawyer's degree, his attorney's degree, and with his experience in information technology and his experience in the human resources profession. And also now he is an accredited accredited in as a Fair Credit Reporting on the Fair Credit Reporting Act with the National Association of Professional Background Screeners. So he knows quite a bit about background screening and the do's and the don'ts in the Fair Credit Reporting Act, and so he's really a wealth of information. He serves on the Best Practices Committee of National Association for Professional Background Screeners, and he co-chairs the Data Breach Prevention Subcommittee, which is very important. And with all of that experience, he's going to take time out of his busy day and give us a webinar on this topic of the recent litigation claims in background screening. So let me move forward. So there it is, recent litigation trends. And with that, I believe we're ready to go ahead and switch screens over to you now, Matt. Okay, we see your screen, and if you'll unmute, I'll mute on my side, and you can.
Great, thank you, Cynthia. Appreciate the introduction, and it's always a pleasure to address this group here today. Yes, and so we've had quite a few of these webinars so far. As you can see, we're up to part 9, and yes, there really is that much information about background screening to share. And today I'm particularly excited about what we're presenting is some information on recent litigation trends. Unfortunately, the plaintiff's bar has found the Fair Credit Reporting Act and are making lives a little more difficult for employers out there when it comes to background checks. So we'll talk about a few things that are out there and try to focus in on some cases too that I think will provide some insight as to not only what the plaintiffs are thinking, but what the EEOC is thinking as well. So with that, we'll jump right into it, and I'd like to give you just a little bit of a refresher on the FCRA, the Fair Credit Reporting Act. We'll go through this fairly quickly because it is in some of the previous webinars that we've done, but just as a way to get grounded in what our presentation is about the Fair Credit Reporting Act applies to all background screening, not just credit, and it's not just for criminal records and not just employees. The Fair Credit Reporting Act applies to volunteers. I know some of you have volunteer or nonprofit organizations out there as well, so it's equally applicable to those types of operations. And if you'll give me just a second, my screen has gone blank. Okay, and I'm back. So some of the goals of the Fair Credit Reporting Act, primarily it's a consumer protection statute. So it's designed to protect the individuals on whom the background checks are being run. There's quite a bit of information that goes into background checks. It comes from all different types of sources. So one of the things that's important is to ensure the accuracy of that information. You probably have seen some news reports about background checks gone awry and two different individuals being confused with one another, one of them a fine upstanding citizen and one of them a hardened criminal. Well, one of the things that the FCRA is designed to help out with is to make sure that the information that goes into the background checks is accurate. So again, that's kind of the primary goal of the Fair Credit Reporting Act. So one of the things that kind of plays into our topic today is the EEOC, or the Equal Employment Opportunity Commission, revised their enforcement guidance on the usage of criminal records in the hiring context. It's been about 2 years ago now. It was in 2012. It's an interpretation of the Title VII of the Civil Rights Act and some other statutes as well. The guidance hadn't been touched in over 20 years, so it was kind of a long time coming. But one of the interesting things that came out of this revised guidance, and keep in mind that this is just kind of the enforcement guidance that the EEOC investigators use when they're in the field. It's not new law. Nothing changed with respect to the actual statute. But it is kind of the user's manual that folks are using out there when they're doing their investigations. But the interesting thing that came out of this was it starts with the premise that any usage of criminal records in the hiring context has a disparate impact. And what that means is you have a facially neutral policy, but it has an adverse or a different impact on one segment of the population versus another. As you can imagine, with the criminal stats being what they are, usage of criminal records was adversely impacting certain minority populations. So that's what the EEOC was looking at is, you know, even though this is a noble cause, it's certainly having an indirect or disparate impact on some segment of the population. So that's the premise that they are operating from, and so now it's upon the employers to kind of rebut that presumption of a disparate impact. So the EEOC has always had what they call the green factors, coming out of a case called Green versus Mississippi Railroad, I believe, that when you're looking at criminal records, you have to consider certain factors. The nature and gravity of the offense, the time that's passed since the conviction or the sentencing, and the nature of the position that the person is seeking. So that's been the long time standard, but the revised guidance added this new concept of individualized assessment. And again, I'm going to kind of run through these because, again, this is something that we've covered in previous webinars, but it is sort of helpful in setting up the analysis of our cases that we'll be looking at. So in addition to the green factors that we looked at, other things to consider are any additional circumstances surrounding the original criminal conduct, the number of offenses, so somebody having one minor offense versus several or multiple major offenses, that kind of plays into it. There are some studies that show that a person, if they are older at the time of conviction or release, that they're less likely to reoffend. So that can play into your analysis. Evidence that an individual has performed the same or similar type of work, either post-conviction, that plays into several of the cases that we'll be looking at. So pay close attention to that first one. So what that means is somebody post their conviction and they've been re-released and they've held down a position of a cashier for several years without any problems. They come to you and apply for a cashier position. The fact that they have some good work history post-incarceration would be something that you would have to consider as part of this individualized assessment. And so that kind of plays into the next one there, the length and the consistency of employment history, whatever rehabilitation efforts they've gone through. And then character references, or whether or not a person is bonded in a particular program. So these are all things that would be additional considerations beyond the typical green factors that we looked at initially. So the EEOC's goal, they are trying to eliminate these bright line tests. People that say, I'm not going to hire any convict for any reason, they're looking to eliminate those. They're hoping that employers will develop narrowly tailored policies that look at all these factors that we mentioned before setting up barriers to employment. And also they're hoping that the managers will be trained on how to prevent situations that might result in discrimination. And you can do that by identifying the essential job requirements and the actual circumstances under which the jobs can be performed, and determine any specific offenses that may demonstrate that a person wouldn't be fit for a particular position. So some of the obvious kind of comparisons come to mind is if you have somebody that's got convictions for embezzlement, probably not going to be an ideal person to hire on as your controller. Likewise, showing a disconnect, if somebody has a, let's just say they've had a bogus check writing conviction in their past, does that prevent them from coming onto your site and maybe taking care of the grounds, mowing the lawn on a weekend or something? No, and that's what we're looking at is some folks will have in their policy that they won't hire any convict for any reason, and that would be kind of one of those situations where there really is a disconnect. No bearing on somebody's position in mowing the yard and having a bogus check writing conviction. So that's what we're looking at when we're trying to narrowly tailor these screening policies. And again, just trying to figure out the timing on the exclusions. Some people will look back and say any conviction anywhere in their history is a prohibition. Some states have actually gone on and passed some limitations to the Fair Credit Reporting Act, which really on conviction information, that's an unlimited look back into the past. Arrest records typically will be restricted to a 7-year history, but some states have gone on and said even on convictions you can only look back 7 years. So that's what we're looking at when we talk about determining the duration of exclusions. And I guess there is some report or some type of evidence that shows that the rates of recidivism reduce. There was a famous study by Bloomstein and Nakamura that basically said that once a person has gone 7 years post-conviction, they are no more likely to offend than any member of the general population. So that's where that little magical 7-year number comes from, is that study. And then finally, the EEOC and their guidance, and their interpretation and their recommendations on their guidance, any type of studies or any type of rationale that you consider in determining your policies, they're just wanting you to keep good notes and kind of document that information. So to wrap up the EEOC's guidance, changing your application is probably a good idea. Anything that kind of sets up a barrier to employment on the front end, like the question, have you ever been convicted of a crime? That might be something that you want to review and take a look at. Several states have passed what they are calling Ban the Box initiative, which is actually prohibiting that checkbox for criminal convictions from being on the application. Just making sure that you have updated disclosure and authorization forms, which we'll talk about in a minute. That's another area of recent litigation. And then just making sure that your policies are narrowly tailored. So we're going to look at a few cases here that I think are kind of very informative as to where the current litigation trends are going. And the first three that we're going to look at are particularly tied to the EEOC and their revised guidance. The Freeman case, this is an interesting case. It's really a situation where the EEOC, I think, kind of got out ahead of themselves, and really this ended up in quite a black eye for the EEOC. They had numerous procedural issues, numerous flaws with their expert witness testimony. Judge Titus actually in this case called this lawsuit a theory in search of facts to support it. So it's a kind of a bad case to look at in terms of the practical applications, because the EEOC kind of botched things on the expert witness testimony. But it's actually a good case to look at in respect to what Freeman was doing in this particular instance. And so we'll kind of take a look at some of the things that were going on in this, but just understand that the EEOC is not likely to make a similar mistake again when it comes to their expert witness, and the problems that they experienced with their science are not likely to be repeated. So let's take a look at what Freeman did right. Actually, we skipped one. Let's see. I just wanted to point out a couple more things that to show you how bad this was. If any of you are attorneys out there and you ever have a judge talk about your case in this manner, it's probably one of those things where you hang your head in shame and really ask yourself, why did I go in this line of work? But the expert analysis basically was called distorted, both over-inclusive and under-inclusive, an egregious example of scientific dishonesty, and that's really the killer right there. I mean, to have the judge talk about your case in that manner as a clear case that something was amiss in terms of the preparation. The other interesting piece was that there really was no one particular practice that Freeman had in its workplace that the EEOC was pointing out as being the cause of the disparate impact. They were basically, again, just supporting their general premise, which is, well, if you're using background checks, you must be discriminating. So this, again, is just a bad case being put forth. But what we can learn from it is these are all the things that the Freeman operation was doing right in their background check program. First of all, they actually would offer the job prior to doing the background screening. So it was a conditional job offer upon successful completion of a background check. That's good, because the further you can move that background check into the process, the less likely you can be seen as having barriers to employment. They were only looking at convictions or release from prison within the last 7 years. Again, there are some 7-year states, but this the case actually I don't think was in one of the 7-year states, but that's something that they were doing. They were already restricting that to a 7-year look back. And then they were looking at the offenses in relationship to the positions being offered, and we saw that as one of the requirements under the green factors. And they also looked at the severity of the crime. So that's important because it shows that the cases were, or the screening program was narrowly tailored. Violent crimes, destruction of private property, any type of sexual misconduct or felony drug convictions, those were of the highest concern, and so those were treated differently than other lesser crimes. They also looked at warrants and gave applicants a reasonable amount of time to resolve those situations. That's one of the things that the Fair Credit Reporting Act actually requires, and we'll talk a little bit more about the pre and post adverse action notices, but there was actually opportunity for the applicants to correct negative information or to take care of outstanding warrants or situations prior to a final decision being made. They allowed upper level HR people to make the decisions rather than relying on the lower level hiring managers. And then they also only looked at credit reports whenever there was a job-related issue to do so. And that's another thing that we're seeing in terms of state legislatures kind of getting on the bandwagon of reducing the access to credit reports, limiting it to just positions that deal with fiduciary responsibilities or access to client, confidential client data that might include, say, credit card numbers or account information like that. So they were already doing all these things. What's more, they even had a policy which stated their goals for their background check process. They basically said that their background checks policy or practice was designed to avoid exposure to negligent hiring and retention. I mean, that's pretty much the most common justification. But the difference here is they actually had this spelled out in their policy, which I would highly recommend that you incorporate into your policy as well. They also were desiring to increase the security of its property and security for their other employees, reducing liability from inconsistent practices, proactively reduce the risk of employee loss. So anytime that you deal with a retail type operation, employers know that shrinkage and other types of employee theft are problems. So they were basically spelling out in their policy that that was what they were trying to prevent. And then just trying to mitigate any type of situations that would happen on their property or anything that would kind of deal with employee or consumer confidence in the organization. So those were all the things that the Freeman case did right. Again, the EEOC primarily lost this case because of their poor showing in their expert witness testimony. And I think you can also see that all the things that the Freeman case, the fact that they were doing all these things is also probably a good part of why that didn't go forward. But I would probably encourage you to look more at what the Freeman case, what Freeman operation was doing right versus relying upon the EEOC having another bad showing in terms of expert witness, because that's not likely to happen again.
So, Matt, then it was the EEOC that did sue or bring the case against Freeman?
That's correct.
And it was in a hiring or in the case of a hiring decision?
Correct. Yeah, it was basically what made them pop up on the radar was they basically had a statistical anomaly or a showing of disparate impact. They had a facially neutral policy of just doing background checks on all employees, but it was having an adverse impact on minority populations in terms of who was getting hired.
Were able to support, obviously they were able to support that they had, they were following the letter of, it looks like to me that they were following those practices that, based on what you showed us, that they were making a good attempt to do that. Yeah.
Exactly. And part of what was happening, the scientists in this case had access to over 58,000 applicants and data on 58,000 applicants. But basically, his study limited to his sample to 2,000 of those, and most of those 2,000 happened outside of the time period for which the lawsuit was brought. So, again, just they were really trying to slice and dice the numbers to make a point, and the judge just slammed them for it. And then on top of that, you put all the things that this company was doing right with respect to their policies and procedures. Just really ended up being one of those situations where that case should have been dropped and settled long before it went the way it did. Which, coming off the black eye that the Freeman case represented for the EEOC, you got to feel sorry for the next guy that comes into court or comes into the crosshairs of the EEOC. And here are the next guys: BMW and Dollar General. And these, I think, because they're still in litigation right now, we don't have as much information as we did on the Freeman case, but I don't think these are going to go quite as well for the employers. Just looking here, you can see what makes these two cases attractive to the EEOC, because you have these statistical problems. In the BMW case, we'll talk a little bit about the facts here in a second, but you had 645 employees being checked, a little over half of whom were African American, and then you have 88 employees were rejected, and 80% of those were African American. So you can see that there's a much higher rate of rejection than the population would suggest. Similar thing to the Dollar General case. 344,000 employees were being checked, 25% African American, and then 31% being rejected. So again, the rates of rejection were higher than the general population. So what else can explain this but just outright discrimination? And that's the EEOC's position. So we'll take a look at the BMW case first. It's an interesting situation. In the BMW case, it had to do with a changing of contractors. There was a warehouse facility where employees of a subcontractor were employed. So the actual employees were those of a company called UTI Logistics, I believe. So they were positioned in these warehouses, and BMW was going to be changing contractors. So anybody working in the warehouse that wanted to keep that job were basically going to have to go reapply with this other contractor. And so what happened is, when these employees, some of them who had been working there for 14, 15 years, when they were reapplying, they went through another background check, and this other subcontractor the policy had changed. So originally there was, with UTI, the original contractor, they would only go back a certain time period, 7 years in their history. But when they changed contractors, they had them apply BMW's policy, which was no time limit with respect to convictions. And there basically was a blanket exclusion without any individualized assessment regarding the nature and the position of the crime. So these employees, again, one of them in particular, had been there for 14 years, had a minor narcotics possession conviction in their past, and that person was not rehired. So this is exactly what the EEOC was saying when they said, looking at the person's post-conviction job history. So this person had been employed for 14 years, and now all of a sudden this minor possession conviction is a barrier to employment. So the EEOC goes, that's what we mean. This is what individualized assessment is all about. That's a ridiculous situation, and therefore it's a violation. So that's kind of what we're looking at. Probably one of the best examples in terms of fact patterns that we have that points to the individualized assessment concept. So we're kind of following this case pretty closely and trying to see what comes of it, so we understand how much of that post-conviction job history is going to play into your analysis. So the Dollar General case is similar, slightly different, still pointing out to the post-conviction job history, but two different facts. One applicant was denied a cashier position because of another drug conviction. This time it was 6 years old. However, there was no previous job history with Dollar General, but this person did have a good work history with another retailer in a cashier position for 4 years. So prior to applying at Dollar General and after their conviction, they were able to hold down that position for 4 years, and there's nothing to indicate that there was any problems at that other employer. So in general, just a good work history. But Dollar General basically said that no, it doesn't work. This person has a drug conviction. Our policy is not to hire anybody with a drug conviction. Sorry, you're not hired. And then there was another applicant that had advised the store manager during the hiring process that the background check information was incorrect, that it belonged to somebody else. But basically they weren't given an opportunity to correct that information, and they were refused, the company refused to hire that person. So another situation where, not given an opportunity to respond and given some chance to correct the inaccurate information, and therefore the EEOC says, look, that's another thing that we're looking at. We want, and that's really more of the FCRA responsibility than the EEOC, but still it was all wrapped up into the same case. So we have two pretty good fact patterns here within the Dollar General case that should provide us some guidance once there's some resolution to these two cases. Now, this situation with the revised guidance, it's a couple years old now, and it's kind of died down with respect to the people's interest in the case. But right after the guidance was passed, there was a little bit of a hubbub, and then it was actually the following summer when 9 attorneys general sent a letter to the EEOC asking them to rescind the guidance. It was pretty much right after these two cases were filed is when the attorneys general basically said that this is junk, this is new law, it's interfering with business. Of course, the two home states of BMW, that facility, and the Dollar General corporate headquarters, those attorneys general were represented in these 9 states. So they fired off this letter to the attorneys general saying, basically, drop these cases and rescind your guidance. The EEOC responded, basically saying, this is just an update to long-standing policy. There's nothing in there that urges or requires individualized assessment, which I call bogus on. It does encourage a 2-step process of targeted screening and individualized assessment, which that in itself is kind of an inconsistent statement given the bullet points above. And the last thing they mentioned said that, this guidance isn't what's preempting this negative behavior, it's Title VII, and which really just kind of brings to front that the guidance was not new law, it's just a further interpretation of Title VII. Now, it's interesting to note, none of these situations are without having some little bit of a politicized angle to them. The commission, the EEOC, is made up of 5 commissioners, 3 Democrat and 2 Republican. Now, the attorneys general, all 9 of the attorneys general that wrote the letter happen to be Republican. So you can see just a little bit of a political angle shaping up on this. But as I said, most of that has kind of died down. The EEOC hasn't rescinded their guidance. They continue to push forward with what they're doing. And again, they're looking at some of these cases now that they think they found a couple of good examples of where that guidance is not being followed. It is interesting to point out that Commissioner Berrien, when the guidance was passed, one of her quotes was, at the outset, I want to make it clear that it's not illegal for employers to conduct or use the results of criminal background checks, and the EEOC has never suggested that it is. So we at least have that on record, indicating that they're not looking to ban outright the use of background checks. But I do think it's a cautionary tale in that employers need to be using them in the proper way and not to set up some absolute barriers to employment by screening out all convictions. I'm going to switch gears a little bit now away from the EEOC and more towards some of the things that we in past webinars have been trying to draw your attention to in terms of what your obligations are as users of background checks. And I mentioned earlier that there have been some class actions. And these are important because, as I mentioned, the Fair Credit Reporting Act does have statutory damages available and anywhere between $100 and $1,000 for every violation. And so each violation basically is potentially every applicant that is going through your organization, from from whoever is filling out the job application, seeing your disclosure and authorization forms. So you multiply the number of people that are applying by 1,000, and you can see why some of the plaintiffs' attorneys are going after these cases. But we're going to look at a few of these cases here. I don't really have a whole lot of the details in terms of the fact patterns. That doesn't really matter, just because it's a pretty straightforward approach for each of these cases. In the case of State Farm, basically they were failing to provide plaintiffs with a copy of the consumer report and a statement of rights under the Fair Credit Reporting Act before taking action. So I guess it'll be good to go back and give a little bit of a refresher on the obligations of the end users as well. So there's only a few things that employers have to do under the Fair Credit Reporting Act, but they're very important. One is the adverse action process, and that's where the majority of these cases are falling. For employment cases or for employment screening, it's a two-step process. Prior to taking any adverse action, and we've defined adverse action in the past as any negative action, like not hiring, not promoting, not retaining. So any negative consequence is considered an adverse action. So prior to taking any adverse action, the employer has to provide notice to the consumer or the applicant. And that notice, basically, it can be oral. It can be. It's probably better to be written, so you can have better documentation of it. But basically, you have to give the applicant a meaningful opportunity to respond to any information that's in the background check report. So if there's anything in that report that may cause you to take negative action, the consumer has to be notified of that, and they have to be given a copy of the report. And they also have to be given a copy of a document that's set out by the FTC. Actually, now it's provided by the CFPB, the Consumer Financial Protection Bureau. But the document is called a Summary of Your Rights under the Fair Credit Reporting Act. So you have to notify the individual, give them a copy of the report, and give them a copy of the Summary of Rights document. And that's what State Farm was allegedly not doing, was giving them a copy of the report and a copy of this document. So as I mentioned, it's a two-step process. The first step is to provide all of what I just mentioned, but then give them an opportunity to respond and correct information that's in that report. The Fair Credit Reporting Act doesn't say specifically how long you have to wait or how much time you have to provide. But the FTC opinion letters have basically settled into a 5 business day period. So the consumer gets 5 days to respond and either say, no, that's not me, or no, that information's been removed from my record, I don't know why it's still being reported. Whatever it is that they can say that would make you possibly change your mind. And then only after that time has elapsed do you follow the next step, which is if nothing has swayed your decision, you send out a post-adverse action notice. And the Fair Credit Reporting Act spells out a few things that have to be included in that notice. Some of those things are you have to provide the contact information for the consumer reporting agency or the background check company that produced the report. If they're a nationwide company, they have to be you have to give them the toll-free number. You also have to include a statement that the consumer reporting agency or the background check company didn't make the decision to not hire, and they have no information on why that decision was made. And then you also have to notify the consumer that they have a right to obtain a copy of their report for the next 60 days at no additional charge. So there's very specific things that have to be in that letter. and that's the post-adverse action process. So pre-adverse action, waiting period, post-adverse action, that's the process. The other area where there is quite a bit of litigation going on right now, and unfortunately it's one of those little technical gotchas, it's the disclosure and authorization forms. So prior to obtaining a background check on any employee, you're required to disclose the fact that you will be obtaining a background check report. Now, the Fair Credit Reporting Act says that that disclosure statement has to be in a completely separate document that consists solely of the disclosure. So I can see what you're doing right now. You're thinking in your head, well, I think we've combined that with our employment application. It's all embedded in the same thing. We're trying to save paper. Well, that's exactly what the FTC is trying to avoid, is that little disclosure statement gets buried in the middle of a huge employment application, and there really isn't an effective disclosure that's being done. You're trying to sneak one in. So unfortunately, the plaintiffs bar, these attorneys are going in and saying, oh, well, this is on the same piece of paper, or it was handed to my client as part of a bigger document. Therefore, it's a violation of the Fair Credit Reporting Act, and thank you, I'll take $1,000 for every time you've done this. So that's what some of these cases are about. In fact, I believe it was the Whole Foods case you see at the bottom that was just recently filed. It was about the disclosure and authorization statement. Now, the other piece to that is an authorization. So you have to get written permission to actually do the background check on the employee or the applicant. And so one thing that you see often too, in addition to employers trying to make this part of a streamlined application process and combining it with the overall employment application, there's also a tendency, especially once the attorneys get involved, to want to include a waiver of rights, a disclaimer statement regarding background checks, saying that you can't sue us if we do this. Well, those disclaimers, those waiver of rights, typically will run afoul of the Fair Credit Reporting Act, because you can't have somebody sign away their rights under the Fair Credit Reporting Act. So unless you have really threaded the needle appropriately with that waiver of rights, those typically will run afoul of the proper disclosure and authorization statement. Now, the Fair Credit Reporting Act does say that you can combine the disclosure and the authorization form on one page, but then once you start putting those additional things on there, any other extraneous information like a waiver of rights, that does invalidate the form. So that typically that's what we see the most of, is getting other questions on there, especially combining where some states have done ban the box. Remember that, have you ever been convicted of a crime? Putting that checkbox on the same statement. Really anything else that you can put on there will create problems. So one thing I would highly recommend is you look at those disclosure and authorization statements that you're using right now, and just see if it's clear and conspicuous in terms of what's being done on the disclosure. I would really at this point recommend that you put that disclosure statement onto a completely separate document. Don't combine it with anything else. And then on your authorization form, just make sure that if you are including any type of waiver of rights, that it doesn't go overbroad and potentially run into problems with the Fair Credit Reporting Act. Because you can see here the State Farm case, the U.S. Foods, Walmart, and Disney, all of those in the U.S. Foods, they were basically taking adverse action against plaintiffs without providing the pre-adverse action notices. So they may have gotten it part right. They may have been sending out the notice that sorry you didn't get the job, but they weren't giving that pre-adverse action step. Same thing with Walmart. Again, this goes back to the adverse action notification process. And then Disney, I had a kind of a combination of situations. They were failing to provide the pre and the post adverse action notices, and they were not giving a copy of the consumer report to applicants. So it's a pretty easy thing to avoid in terms of litigation on the usage of criminal background checks in the hiring process. The two big things to watch out for are the disclosure and authorization and the adverse action process. I would suggest that you maybe go back and watch a couple of the webinars. Probably can get you the information exactly on which ones cover the information in the most detail. And you're always also welcome to contact myself, or Cynthia can direct you to further information on that as well. But the basics for today are going back and understanding the EEOC's guidance on the usage of criminal records in the hiring context, making sure that your application is up to date, and look out for those state law issues where they've done bans on credit checks or banned the box, anything else, just making sure that your application's up to date. Those authorization forms, unfortunately, it seems so ridiculous that these technical issues about single pieces of paper are resulting in class action lawsuits, but that's the letter of the law, so make sure that you're following it. And then just make sure too that the adverse action process is something that you're aware of, and you know both steps, and you know the proper waiting period. And then finally, just understand what the risks are. The FCRA does allow for $1,000, up to $1,000 per violation. So if you have a lot of applications going through your office, just multiply that by 1,000, and you can kind of understand too what the risks are. There's also, of course, the typical attorney's fees and punitive damages that can apply as well. So just be aware that the FCRA does provide for that as additional threats, I guess you could say. But that's what we have for you today. If you have any questions, Cynthia, if you've seen any of those come through, just let me know, and we'll be happy to answer those. Otherwise, appreciate the opportunity to make you aware of some of these exposures out there, and always happy to talk to you and help you how to avoid those.
By the way, on the last slide, it looked like many of those companies, Matt, are ones that are quite large, and they have quite a hiring process. And I'm just really familiar with applications being done online. If the hirer, such as Whole Foods or Disney, if they require online application, would it be possible for them to go ahead and take the applicant through a series of, I don't know, windows that would say, here is your um, notifications that they have to, and then here we require your, it's the disclosure you talked about, and then we require your authorization to proceed with any background. Can you do something like that?
Yeah, absolutely, and that's a really good point, because you raise an interesting question with respect to online applications. You know, the FCRA was written at a time, it's a 40-year-old plus statute now. It was written at a time when online applications really didn't exist. So the question when you enter the online world, what is a single document, or what is this? What's a single page on online? And I would suggest that, and I think you kind of laid it out for us, Cynthia, is that when you are displaying the disclosure statement, that you make it on a screen with nothing else on it. So if you scroll up or down, there's no other sections. I think just breaking it off with maybe a couple of horizontal lines, or putting a box around it, if it's on the same screen that where other information is being presented, I think that would run afoul of the FCRA. So I think you would need to have it on a screen where there's no other information, and then you click a next button or something of that nature, and are taken to another screen where you would have the authorization statement. And then once that's gone, either the remainder of the job application, where you're filling all the biographical information and whatnot, would be present. So doing whatever you can technologically to separate those off, where it's pretty easy to see that it's a separate piece of paper. I think you need to make sure that you're doing whatever you can to separate that off online.
Yeah, I I would think that you would have them fill out the application, and then they submit the application, and then you come back with the disclosure statement, and they you can set it up so they're required to read it and then agree or acknowledge that they've read it, and then when they acknowledge they've read it, then come back with, we need your author, in order for us to process your application, we need you to authorize, your authorization for any background screening that might be done. I don't know. It just seems like it would really help facilitate the process when you're doing those. In a lot of those companies you listed do online applications. Just
Sure.
thought, and you with your IT background, I thought maybe you would know that. So just a question for you, Matt, to
Yeah.
investigate.
Yeah, I think you spelled out the right recipe to follow. I think keeping it as separate as possible and not mingling it in with other screen elements. And you're right to point out that most of the cases that you saw on that list, most of those employers were rather large employers, and because that's where the money is. Typically, these plaintiffs will target large organizations because the potential classes are larger, but we are starting to see some smaller to mid-sized employers being targeted as well. Nancy Roberts, who has done several of these webinars and who, like myself, is very active in our industry association, the National Association of Professional Background Screeners, just came back from our typical mid-year legislative summit with some information that there are several plaintiffs' attorneys out in California, but some for us as close as Kansas, where there are about 10 or 15 different lawsuits pending against employers. Just because it is so easy. I mean, it's not one of those cases that requires a lot of interpretation. You have somebody go apply at a employer somewhere and have the applicant snap a few pictures off of the application, and if the disclosure statement is embedded right there on the middle of the job application, you're done. You have a case. You file it, and then you seek to certify it as a class, and then you just decide, well, how long have they been using that particular form? Oh, it goes back 4 or 5 years, I guess. So now everybody that's filled out that form for the last 5 years is a potential class member. So I don't think you have to be an employer of huge size in order for that to start to add up very quickly. So it's just a matter of how active the plaintiff's attorneys are and whether somebody's doing that in your area or not.
Well, and this is why these webinars that you and Nancy are giving are so important, especially for mid-size companies, but even the large companies, because you really are keeping people informed of what's going on. And I've been listening to these webinars, and there is tremendous information, folks, for you to go back if you're in this business or you have a company, whether you're an owner or an HR professional or even a lawyer, like a general counsel for a company. Very important aspect to keeping your company protected and the applicants protected as well. So thanks, Matt. We appreciate that. Just scroll forward and I'll tell folks what's coming up next. We do have next week, Kenna Lewis will be continuing her social media series with Twitter for Business. Kenna does an excellent job for her clients getting business just using Twitter, and has gotten clients herself just using Twitter. So you'll want to come back and listen to Kenna next week. Then we have Dr. Jeff Stewart, who will be back on total business competitiveness. Jeff is an expert in the arena of competitiveness and has been chairman and also advisory on the advisory board for American Society for Competitiveness, and he speaks from knowledge in helping you improve competitiveness for your company and your industry as well. And then we'll have Emily Shoup, who comes back on June 17th with Create Your Culture for Full Team Engagement. And we hope that you'll come back on Tuesdays at noon Central. We have quite a lineup of speakers and topics that are pertinent for today's businesses. And we always love it when you participate. So look for Matt's webinars and other webinars from Track 1 out on businessperformanceusa.org. And join anytime, it's free. And become a member. And you can participate and watch the webinars on demand at a time that's good for you. And I know you will be informed with great stuff like what we had today. Thanks again, Matt, to you. And with that, folks, I'm going to go ahead and end the webinar, and we'll see you back next Tuesday.
Thank you.